Questions, please? Right. Okay.
Right, I'm not a lawyer, so I'm going to try and make this, well, understandable for the panel. In terms of gravity of crime, maybe I'm the one who should understand rather than the lawyers. In terms of gravity of crime, as far as I understand, the ICC prosecutes individuals. African Court on Human and People's Rights prosecutes countries. Is that right? Africa, in the African context. Right.
It doesn't prosecute at all.
No. Right, they go ahead to the countries are taken to the African Court of Human Rights. Right, okay. In a normal everyday court, individuals are prosecutors or taken to court. So should gravity be really included in any situation as the ICC prosecutes individuals, especially in human rights cases? And surely shouldn't the ICC prosecute criminals regardless of gravity, purely in the interest of justice?
Is there anyone you'd like that question to go to? Right, we'll take a couple more before we ask the panel. Over there.
Thanks. I'm a student of African politics at SOAS. I've got a question for Chandra about complementarity. And so complementarity means that there might be a situation where a state government which is under investigation is encouraged to set up or use national courts to obtain a prosecution, or has the option of kind of ignoring that and self-referring to the ICC. What I worry about complementarity, doesn't that mean that if this national government is going to choose a national court, there has to be something in it for them? What could be more beneficial about a national court for that state leader or set of people under investigation over the international courts? I worry that complementarity, if kind of seen in a very self-interested way, could encourage somewhat insufficient or kind of ways out of justice by using the national courts. Do you think that's a problem?
Right, we'll take one more question. In the front, please.
Yes, hi, my name is Luke. I work for Eaton Partnership. It's a public relations communication company based in New York. So my question is for Mr. Khan. You spoke about accountability, but many Fleet Street newspapers or left-wing think tanks around the UK or around the world actually will mention selective accountability. Africa, I suppose sub-Saharan Africa, has been a convenient laboratory for the ICC.
Okay, thank you. If Chandra could answer her question, and then I think Karim, the last question, and then the panel can address the general question about gravity.
Okay.
Yeah, there's a question about complementarity, yes. Chandra. Yes.
I mean, in fact, I think I can try and address the question of gravity, and perhaps I will address in part the question of complementarity, and possibly Sarah's better place to follow on that. I mean, I think it's an extremely good point. Why should we have gravity as a criteria at all? We are actually talking about the most serious crimes in the international system. Why would we think that we pick and choose, as opposed to in ordinary murder, if you actually think you can investigate and find out who is responsible for a whole series of ordinary murders, you would go ahead and prosecute. It does come down to resources. It comes down to a policy choice, as opposed to, I guess, perhaps what we might consider a more principled legal decision. And this is something that, if you look back over the negotiations of various drafts of a prospective statute, it starts appearing as early as 1992, and it's a state choice consistently that this is, they simply don't want a court that's that universal, or they don't want to be responsible for the funding of a court that would have that kind of universality. With regard to the question of complementarity, and again, I think Sarah might pick up on this somewhat better. I think you ask a really important question: why would states actually think that it's important to try cases themselves rather than self-refer or let the prosecutor go ahead proprio motu? I suppose one of the reasons, although this didn't happen in Kenya, but you hear it from Kenyan politicians at various points, and particularly Kenyan jurists very strongly, is a sense that it's evidence that you are, in fact, and I think Sir Geoffrey referred to this, you are actually a functioning democracy with a functioning court system capable of dealing with your own crimes. And persistently in the interviews that I've had with various, again, jurists and politicians in Kenya, what they say over and over again is, no, we're not Sudan. We have a real judiciary. We have a real court system. We can certainly debate the quality of that system, and it's in progress in terms of reform. But I think that's one of the fundamental reasons, is actually a state's sense of itself and what it projects to the international community.
Thank you, Chandra. Karim?
Well, I understand it's really a very general question regarding Fleet Street and people's comments, journalists' comments about the court being selective. I put forward my views that there is a degree of selectivity in the which African leaders are being looked at and which are not. And in my own estimation, and this is my personal view, is one of the reasons for that is the approach taken by the prosecutor. The objective must be to search for the truth and to search for those that really are the authors of crime. But what he seems to have a proclivity to do is to plug into any information stream and is indifferent or doesn't search whether or not that source is polluted at the head. Now, going to Kenya, for example, we all know there's a coalition government. We all know that there are elections coming up next year. And the court needs to be very wary of being used for party political reasons, being a tool to clear the deck politically. Now, we do know, for example, that in addition to the allegations against him, Jean-Pierre Bemba Gombo was the main political opponent of Joseph Kabila. We do know that Raila Odinga, the Prime Minister of Kenya, his main contender is Uhuru Kenyatta. And I think what the prosecutor needs to be, and any prosecutor needs to be very wary of, is being used, not the international court using or abusing African countries or even any other country that it's investigating, but being used by them. And that's a very important point when you come to Kenya, and also when one looks at the DRC and all of that. The only caveat I will say is, not caveat, but the only additional comment I would say when one is looking at this topic generally is when one is looking at denigrating the ICC's most noble objective that everybody, I think, would applaud, one has to ask a very important question, that those that simply rail against the differences of power and they use the ICC as some kind of lightning rod, some kind of punch bag to relieve themselves of their grievances to the inequalities of the world generally, would the trial of Charles Taylor have been more fair if George Bush had been convicted? The bottom line in a criminal matter, leaving aside politics, is, has there been equality of arms? Have the defence been given adequate time and facilities? Have the defence been given equal opportunity to call witnesses, cross-examine witnesses, and test witnesses? And if that's the case, ultimately one needs to have good judges to dispense justice, and one believes that, and hopes that judges will do that. Of course, there have been cases in which lawyers and practitioners have absolutely been aghast, where cases, for example, that we didn't think were going to be confirmed have been confirmed. But similarly, other cases like the Calixte case, like the Abu Ghada case, those judges have been trusted and have actually told the prosecutor, no, you don't have evidence, these people should be at liberty and the case will not proceed to trial. And I think also one can't be, sorry, just to add, because I think I didn't cover it, the other point I think is important to bear in mind is when earlier somebody was talking about Lubanga, one of the panelists, and that really Lubanga shouldn't have been convicted, the evidence is very flimsy. I think one can't have it both ways. These same judges who had the fortitude to be deaf to the NGO community that have a disproportionate voice sometimes in this court, they stayed proceedings because they said the rights of the defence were being violated. When those same judges, alive to their oath of office, convict somebody, I think one needs to be a little bit hesitant, absent good reason. Of course, the appeals chamber will review it, just to simply say, well, actually, that's a bit dodgy. The conviction shouldn't have been entered. There are issues of the quality of fact-finding by the court. Even domestically, we have better judges and judges that are perhaps not as rigorous in their analysis. The same is that on the international plane.
Thank you very much. Sarah, to address the point of complementarity and gravity.
Yeah, if you don't mind, I'll start with complementarity, and I think gravity has been addressed sufficiently. But about the complementarity, so why would states want it? But I think the difficulty that we have with all the debates is that we're talking about several constituencies. And in many cases, the defendant may actually prefer the International Criminal Court. And I think Phil mentioned this morning that Lubanga's mistake was not to challenge complementarity, but I think it was a very strategic decision of the defense because he preferred being tried by the ICC than in the domestic courts. But we are all these different interests. The defendant may prefer the ICC, but at the same time you have constituencies that say, similar to what happened with Saddam Hussein, he may be a dictator, but he's our dictator. And I think in that way we have to think about justice. Justice is a process. We are doing justice. It's something active. And as soon as you take that away from the community concerned, they're less involved and the justice done may have less of an impact. And I would like to, being fascinated by these paradoxes, one of the paradoxes that comes up with me, if you look at where has the ICC actually encouraged domestic proceedings and tried to encourage states to do it themselves, it's usually those people that are least likely to be prosecuted domestically. Whereas there where complementarity actually had a chance, that's where the ICC has discouraged domestic proceedings. So to give an example, all the rebel movements could perfectly have been tried domestically. In a sense, it's not that rebel movements can give themselves impunity. Whereas governments are the ones, of course, that will not easily prosecute themselves. Now look what the ICC has stated. Initially, when it still seemed that Sudan was going to cooperate, the OTP was actually very encouraging of Sudan to prosecute domestically, even though it was the government who was being charged. Similarly with the UPDF, the prosecutor and the ICC president have gone on record saying, well, we encourage Uganda to prosecute the army themselves. So this is the paradox of positive complementarity, that because the ICC is so dependent on state cooperation, it will not give its own cooperation to those cases in which it itself can actually succeed most. And finally, if I make one more point, which is we all talk about politicization of the court and the court being used. But we shouldn't forget one thing. The court, it's not because of Ocampo that the court is political. What the court is doing is by definition political. And it depends, of course, how do you define politics, something that we always avoid, but the way we do it is politics is the opposite of law. Now, in various ways, that's incorrect, if you think about how law is made. But even once law is made, what does law do? Law, and particularly in this case, distinguishes the international community's friend from its enemy. These people are criminals against humanity. Now, is there a better arm that you can have in a war than knowing that your enemy has been internationally identified as criminals against humanity? So, whereas the Nuremberg and Tokyo tribunals were instruments to deal with defeated enemies, the ICC has become, simply by the type of institution it is, it's an instrument with which to defeat one's enemy because the ICC operates in the fog of war. So it's not that the court is being used. This is inherent almost in its mandate. The question, therefore, is not whether the ICC is political, yes or no, because it is inherent in its mandate that it is. The question is whether somebody is accountable for those politics and whether these politics are good or bad.
Geoffrey?
4 short points on selectivity. I completely agree with Tim Allen's point made this morning about the immense success that the International Criminal Court has had in changing awareness and more particularly expectation. Were you to go to the Sherlock Holmes public house at the top of the stairs here and have a conversation with someone about some alleged horrific event in a war zone, that person might readily say, let him go to The Hague. 20 years ago, he couldn't have said that. It would not have occurred to him to say that. The expectations that are so much now higher than they ever were, of course, highlight the degree of selectivity of conflicts that fall for consideration. We've heard about the very clear political ways in which countries are selected or are not selected. Burma, no, for political reasons. North Korea, no. Iran in the past, no. But there is a People's Tribunal to be heard soon. And you heard from Rodney Dixon of other countries. But let me make one other point about selectivity. And it's most readily made by reference to the alleged crime of genocide. It is now well known that if you want to attract international attention and make it impossible for your conflict not to be overlooked, you must put the label of genocide on it. It's a celebrity crime. And what's the best way of putting a celebrity crime sticker? Why? It's a celebrity. And so we have Brad Pitt and Angelina Jolie, whose motives are all, I'm sure, unimpeachable. Actually, no, I mean that, skewing the distribution of the limited resources available to fall for a quite inevitable process of selection and selectivity. And my last point is to answer the question that the chairman asked me, which I didn't answer, is that yes, there will be more trials at the ICC, maybe not that many. It doesn't much matter because there are many other processes, including national ones and others, that may take over.
Thank you very much, Mr. Geoffrey. Well, ladies and gentlemen, it would be wonderful if we could continue, but regrettably we are now into the coffee break, and I see Thomas looking at me from the middle of the audience there. So we're going to wind this up. I hope that you will join me in expressing our thanks to our very eminent panel who have been absolutely superb. Thank you.